This is Office Talk with Annette Stepanian. Hey guys, Annette here, and I'm back with another legal not-so-quickie episode. In this episode, I am totally nerding out about the law with Ryan Morrison, who is dubbed the video game attorney because he works a lot with video game and app developers. We are totally geeking out over privacy policies and terms of service. Chances are you have them on your website in that footer, but more than likely you've never reviewed them and you don't realize what impact that has on your business. So we're talking about what he has seen with his practice and his clients when it comes to that, as well as just general startup issues, whether or not you should invest in trademarks, things that are coming down the road with the FTC or the Federal Trade Commission regarding online businesses. So I think you'll find this to be a very informative but also entertaining conversation. So with that said, let's go to the show. Hey Ryan, thank you so much for being here today.
My pleasure. Thanks for having me.
So I'm really excited to talk to you because I actually first came across you when I was doing my continuing legal education. For those of you who don't know, lawyers have to do continuing education every few years, and they are incredibly boring.
It's lawyer homework.
It is like lawyer homework. Yeah, it's like mandatory homework. And I saw your session and I was like, wow, he's so engaging. I actually listened and paid attention to what you were saying.
So why did you click video game law, CLE, before we even get to what I do or who I am? That's very interesting to me with what you do and what you're interested in.
Well, it was a bundle, so it was included.
Okay. Gotcha.
Yeah, sorry, Ryan. But
no, hey, you never know.
Yeah. And so I was like, it was definitely relevant. I thought you touch upon a lot of the issues that I come across with my clients and my audience. And so I was like, I have to have him on and talk about video game law and everything else. So before we dive in, can you bring our listeners up to speed about who you are and what you do and all that good stuff?
Sure. So I have a very strange niche practice for sure. I, like so many other attorneys, was about to start my pathway down the normal job after you graduate, get sworn in. I was going to do trademark law, and I was a big fan of a website called Reddit. And on that website and in that community, there was a lot of people getting attacked by Candy Crush, the game that everybody's had on their phone at one time or another. They were trademarking the word candy and trademarking the word saga. And they went after a bunch of, mom and pop video game developers. I had never in my life thought that I would be helping someone like that, but I reached out to a few and said, hey, if you want to fight this, I'll help you for free. Because they were right. They just couldn't afford a lawyer. And through some magic, I won. And Reddit started referring to me as video game attorney. Twitter started calling me video game attorney. So I changed my name to that and kind of ran with it. And now we far and away have probably the biggest digital entertainment firm in the world, which is YouTube, Twitch, video games, of course, and competitive video games, which are known as esports. And we work with all of those different talents and influencers. It's an entertainment law firm that every actual old school entertainment law firm laughs at and calls us fake entertainment.
I want to know, have you trademarked the term video game attorney?
No, it's descriptive, probably. I don't know, but one day.
And if you guys don't know what descriptive is, we can talk about that as well. But.
Yeah, sure. But we work with a lot of startups too. So it's not just, what you would think of with entertainment. It's not just the famous YouTuber. It's also the guy who wants to start a video game company and he's still in his dorm room, or we actually just started helping a knife distributor company, but they want to do everything through the internet instead of door to door and stuff like that. So if you're 1% tech savvy and you're looking to get into the next wave of the future, that's who we work with, no matter what industry you're really in.
Yeah, and that's the kind of folks that I work with a lot. I mean, a lot of us are running our businesses primarily online, and it's a virtual business in a lot of senses. So I want to kind of talk to you about what have been your experiences working with clients when they are starting and growing a business online. And I put those in kind of quotes because it's not your traditional brick and mortar. What are some things that people need to start to think about as they build their business and their audience online?
Sure. So the number one thing we see, which is scary and terrible, no matter what your business is that if you're hiring a contractor to do something for you, that contractor keeps ownership of everything they make, even if you pay them for it. So what we see a lot online is a startup will pay someone to design their logo or make their website or do whatever. And the person who makes all that owns all that. So if you paid some kid $100 to do your logo 10 years ago, chances are he still owns that logo and you just have a license to use it. That's what you paid for under the eyes of the law. Without a normal and real contract with a proper assignment clause, you might be in for a really rude awakening that we see happen a lot more than you think. There's a plethora of other problems that startups run into, but that's the biggest one we see most often, probably.
So, for example, in your world with video games, people are working with contractors, developing I don't know what you develop, I guess, code in the back. I have no idea.
Yeah, well, it's everything. So we actually just had it happen with a clothing company. They had a logo design for their web store, and a year later, the company was doing really well. And the kids saw they were doing really well who designed their logo for them, came back and said, hey, I own that logo. I never signed anything for you. You have to stop using it or pay me a ridiculous amount of money. And at that point, they had already branded under that logo so much that they were stuck paying it, basically. Yeah. And that's what gets scary.
Yeah, and that's why I always tell folks, like, you need to understand the basics of this so that when you find yourself in a situation, you at least can identify those issues and know, wait a minute, like, this is something that I need to negotiate. Like, I want to have the rights to that, the copyright, to the logo or whatever. And so that's why it's so important and critical for people to understand this now rather than later. And so
yes, it's always cheaper to fix it beforehand.
Yeah, awesome. So I love it. I was telling you earlier, I feel like you're like the male version of me. In terms of like what we're doing and what we're saying and how we're trying to get clients to really understand what the kind of the rules of the road are.
Yeah, and I think we see the same thing with both of our client pools where it's not that everyone's anti-lawyer. It's not out of a movie where it's, haha, I hate everyone who works in that field. What it is instead is in startup world, it's not anti-lawyer. It's just absent lawyer entirely. They just never think about it. And that's a lot of what I do, and I'm sure what you're doing here too, is spreading just awareness of, hey, stuff can go wrong, and you can spend a couple dollars now to prevent it, or you can spend a lot later to try to fix it. And that's the important conversation that all these startups need to have.
And so what do you tell somebody when they're like, well, yeah, that sounds great, but I'm strapped for cash, or I just don't have the resources. I'm not being funded by a VC, like how do you convey the value of what we're doing early on in the game so that people understand and make that investment up front?
Yeah, and that's important because it's one of the most common questions we get or common feedback we get is, yeah, I would love a trademark, but I can't afford it. 99% of the time, that's somebody saying that before they know what it costs even. They just assume, oh, a lawyer is $10 million. I can't afford that. No matter where you live in the country or what you do, there is a lawyer who you can afford and that you can work with. It might not be everything you need, and it might not be, the quality of a $1,600 an hour attorney, but plenty of firms, I'm sure you do, I know we do, we work with people on prices and we are happy to make it an affordable value. But what you have to realize, more important than all of that, and I'll use it in a video game context, although it's true in any startup world, the law doesn't care if you make $1 or $1 million. If you're doing something, you're liable for it. And if you want to create a game, that's fine, but then don't sell it anywhere. Don't send it to anyone. You can make it for yourselves and your friends and just keep it there and play there. But the second you release something or the second you put something out to the public, you're now a business owner. And with starting a business comes startup costs. And a major part of startup costs for a virtual company are their legal bills. Not to be a commercial, but we offer something called the Jumpstart package. And I'm sure every attorney who works with startups has similar, where you basically bundle the things you need together and give it at a discount. And it's silly of people in an entrepreneurial space to say, oh, I can't afford a lawyer. I'm not going to deal with that. That's too much money for me. I'm not backed. Consultations are free. Go talk to a lawyer. Get your thing figured out. Otherwise, you're being just incredibly irresponsible and very, silly in my mind.
Yeah. Hashtag all of what he said. So, okay, cool. So I just came back from a conference where a lot of people are building a business, like I said, like purely on social media. I mean, they're quote unquote influencers. I didn't know that could be a job title, but apparently it is. So they're YouTubers, they're Instagrammers, they work with big brands. What are some of the things that you've seen coming down for these folks that they need to be thinking about from a legal perspective as they build their audience and start working with big brands like this?
Yeah, so we work with a ton of them, and you'd be surprised, even the major deals they're doing that are $10,000 for one Instagram post or whatever it might be, They don't even have a contract. They just agree to everything over an email. They have no payment terms. So many of them come to us and say, hey, this company never paid me. Can you help? And there's just no agreement in place. They just did something because they had a phone call and thought that was the right thing to do. It's the same as I just said about the video game developer. I get that your skill set is not the law, and that's fine. It doesn't have to be. But if you're making money for something, you should have an accountant and you should have a lawyer. If you don't, it's your fault when things go wrong.
Yeah. And Ryan, I think we both picked the wrong profession, because if people are getting paid $10,000 for a post, right? Seriously, that's what I was so just impressed by. I was like, wow, people are really making big deals, and oftentimes there are no contracts. So what do you recommend then in that situation where sometimes the brand will have a contract, but if they don't, does the influencer then turn around and say like, hey, happy to do it, but I'd like to get these terms in writing?
Sure. And what's even scarier is the people who were coming in promising to fix it. So more than you have to vet the company you're going to have a deal with, you also have to vet who says they have your back. So lawyers, as a rule, we have to because of the licenses we have. If we're not truly on our client's side, we can lose our law license and we can hurt our entire livelihood. So usually a lawyer will be on your side. But there's a lot of quote unquote managers and quote unquote talent agents that come in and they say, hey, influencer, I'll negotiate that deal. I'll make sure the contract's safe and you give me 30% of everything. And what that does is usually not work out into a good deal. It's just lost money, and that agent or manager's done nothing to actually help you.
Yeah. Yeah, unfortunately, I see a lot of people they get burned, and then they learn their lesson. And maybe that's just the process here. But I think what you and I are trying to do is say hey, you're creating something amazing. You're working hard. Let's try and protect that as much as possible. So, okay. So I have started to see a lot more people working and trying to create apps and different technologies, maybe not video games, but more and more people. Yeah. I haven't tapped into that market. I'll leave that to you. But,
I appreciate it.
Yeah. So what are some things people need to be thinking about once they're trying to enter into the tech app space? They want to put an app and sell it on iTunes. How is that different than maybe some more traditional ventures that they might pursue?
Sure. We're actually doing this with good timing because the FTC just came down with guidelines on privacy policies. So privacy policies there's two documents that everybody clicks OK to and doesn't read: the terms of service and the privacy policy. The terms of service basically says that you don't own what you're downloading. If you buy a book on your Kindle, you're not buying that book. You're buying the right to display that book on your Kindle, and that's it. That's why there's no used bookstores for online versions of stuff. That's why there's no used app store. Whenever you buy something digitally, you do not own it. And the terms of service says all that. That's what you're agreeing to. As a business owner, you want a terms of service because it protects you from getting sued a million different ways. And unfortunately, you need one tailored to you. You can't just say, oh, Disney has good lawyers. I'm going to go steal Disney's terms of service. Because if it's over-encompassing like that, it won't protect you. And a judge will throw it right out. We actually had a client who did that specifically with Disney, went to court over it, and he forgot to Control F half of the thing. So half of his terms of service still said Disney in it. Wonderful stuff. But the other document is the privacy policy. And the FTC has been fining people pretty randomly with it, whether they are video game companies or just any app in iTunes or the Android store or whatever it might be. The privacy policy says what you track. So if you're keeping users' emails, if you're looking at their contact list, whatever you might be doing with it, you need to be disclosing that. And it needs to be in that document. And sure, no one's going to read it, but it needs to be there. Otherwise, these aren't like slap on the wrist fines. These are hundreds and hundreds of thousands or tens of millions. This is life ruining stuff if you don't do it. So again, it's the kind of thing where you can take care of it now super cheaply with an attorney or pay potentially a really heavy price later.
Yeah. And so are these people because I could think about, some of my clients saying, well, FTCs, are they really going to come after me? I'm just,
right.
I'm just a little, maybe not old, but just a little selling my whatever, greeting cards or whatever it is. Do they really care? I mean, so you said there was a few examples of the FTC coming down and finding, different companies. What are some examples of that?
What's scary with them is they're a big believer in, instead of rampant widespread fines, they come down at, instead of little slap on the wrist to everybody, they come down with a bazooka on a few people. And if you look, you can actually go to the FTC's website and they have a list of everyone they find with the dollar amounts and the ruling on why. And it's scary stuff because a lot of them are I mean, one app had like 12 users and they got a $100,000 fine.
Really? Oh, wow.
And it's terrifying because they did nothing more wrong than a lot of other people in that space, but that's who got slapped. And they're trying to show, hey, we're coming after anyone and everyone who doesn't follow this. And the reason I said it's good timing here is because they just said March 15th, I believe. I have to double check that. But I believe March 15th, you're going to no longer even be allowed in iTunes or the Android store without a privacy policy. Right now, 83% of apps don't have a privacy policy, which is a huge finable offense by the FTC. And I believe the FTC moved the fines now to the app stores instead of the individual apps for this. But if you don't have a proper document now, you're going to get thrown out of the stores. And then if you go make your own website or you're through something else, then the FTC is going to come back after you. So it's the right time to shore yourselves up legally.
That's interesting. I thought like iTunes and, Android, all that stuff, like the store itself had requirements before you had to upload an app into their store. Like I thought the privacy policy terms of service would have been on that list of things to do, but
they are, but they also don't care. There's two groups that have more power than America, and it's Google and Apple. They literally don't care what the law is. They say, all right, come stop us, Uncle Sam, if you don't agree with us. So it's a little ballsy, but they're complying a lot more than they were March 15th, it sounds like.
Interesting. I'm going to have to look that up, and I'll link that in the show notes. So if people want to go, for some reason, read all of that stuff.
Super, super exciting stuff.
I mean, to you and I, that's kind of nerdy, cool stuff. So I'm definitely going to check that out. So I find that like a lot of my clients, they actually really want to do the right thing. Like they don't want to get in trouble. They don't want to piss people off. So, but they just don't know what to do. So like you said, with the terms of service, what are some things that they need to be thinking about when they are preparing their terms of service or reviewing them? Because it's not a set it and forget it type of thing either, right? It needs to constantly be reviewed and updated.
And that's the not fun part, is that privacy law and what's in those terms of services, we're all still figuring out the internet. The law is 20 years behind us, behind technology, and that's always going to be the case. So every month there's a new decision that quite literally could just mean you have to change where the comma is in a paragraph to make the wording still meet the legal requirement. For a terms of service, they've changed the law 30 times on how you actually comply with it. So does a user just have to click OK? Can it just be on your website? Do they have to tick a box and then click OK? That stuff keeps changing, and it's important to be up and aware on it. And you're running a business. I don't expect you to sit there and, as Mr. or Mrs. Entrepreneur, sit there and study this stuff every time. But again, build a relationship with an accountant for all the tax loopholes that will save you thousands of dollars, and build a relationship with a lawyer where you can spend all that money you saved with your accountant. And, in all seriousness, that's where you save it. Because with the terms of service, it's hard to say, here's the 3 clauses you want to make sure are right, because there's so many. But basically, what you do with them is you outline your refund policy, which is usually no refunds. That's just the safe way, because then it allows you to give a refund and you're a nice guy, but you're never obligated to. The other stuff is you make it clear that a big part of the problem with the internet is, to get into lawyer talk, you have minimum contacts with everywhere in the world. And what that means is you're opening yourself up to a lawsuit everywhere in the world. What the terms of service can do in most jurisdictions is pull it back and say, hey, I'm based in America. I'm only liable in America. If you want to sue me, you have to do it here. Or I'm in England. If you want to sue me, you have to do it here. However, wherever you are, that's the kind of stuff you want in there to help control your liability, which can get crazy very quickly. Yeah,
it's crazy. I mean, it's such a new frontier. And like you said, the law is just so notorious for being so behind. It's probably maybe 10, 15, 20 years behind in terms of where we are with technology.
Well, I mean, and then if with our current political atmosphere, we might be 50 years behind. Haha.
Yeah.
Kidding. We won't do politics.
Yeah, that might be a whole other episode. Yeah, no, it's interesting. And so I understand the frustration when people come to me and they're like, but I want an answer. Is it, black or white? And you're like, well, the law has a lot of shades of gray, no pun intended, but also it's behind. It doesn't.
That's the hardest part. We're using laws written for newspapers to try to control the internet, and it's difficult. And it's a conversation that a lot of the clients don't want to hear, that there is no answer, but here's a really good guess. Here's a really educated answer for you based on a lot of experience and seeing where other people get hurt. That's the worst part here. The attorney with 30 years of experience in trademark law knows less about trademark law in this space than I do because I see the people getting burned every day here. We're more up on that. And he might have put in more trademark applications over those 30 years, but I know what a new entrepreneur needs to be afraid of when choosing a name and marketing something and everything like that.
Can you tell us a little bit about what those things are that they need to be afraid of?
Sure. So as I said with Candy Crush, I mean, you wouldn't have expected that if you made an app with candy in the name, but those are the kind of things you want to protect. So the trademark and copyright are thrown around interchangeably, but they're very different things. Copyright protects your art, your code, your long form stuff. The trademark, arguably more importantly, it protects your name. It protects your brand. So it's your name or your logo or your slogan. But that kind of stuff, you know, the McDonald's name is a trademark. McDonald's Golden Arches is a trademark. And ba ba ba, I'm loving it is a trademark. Those three things encompass your brand, how you market. And that stuff needs to be really well thought out. A trademark takes 6 months to 2 years to get, and it's not always a yes. The test for whether you're going to get it or not is whether it's confusingly similar with another product in that same space. So I can't open, you know, Domino Pizza and say, hey, it's not Domino's, because that's still confusingly similar, and I'm going to be told no. The other big thing is, like I said earlier, and we see this all the time in startups, like we were joking about trademarking video game attorney. Well, it's descriptive because it means I am a video game attorney. And that would be unfair for me to trademark that and then not let other people call themselves what they do if there is another attorney who practices in video games. So if a word is descriptive, it's not okay. So Apple brand computers, fine. But Apple brand apples would not be okay. Make sense?
Totally makes sense to me.
Sure. Yeah. Yeah. That's the trick is explaining that to people. And then it's very easy to get the outrageous headline like, can you believe they trademarked the word apple? Well, yeah, because trademarks are broken up into classes of goods. It's not like they own that word in every medium.
Yeah. Yeah. It was funny because when, oh my gosh, Black China filed a trademark application to do Black China. I was like all over it. I was like my two favorite things, like law and the Kardashians in one thing. But in that situation, though, I didn't really follow it too closely. I know the Kardashians objected automatically. Their lawyers will object to any filing like that. But that's her name. Can she use that?
That's a wonderful question. It really depends. So, if my name is McDonald's, it doesn't mean I can open McDonald's Burger Company. My last name is McDonald. There's lines with where and when you can do things. There are certainly exceptions, but that's where it gets dangerous because I don't want to say, yeah, you can use your name. There's exceptions. And then someone listening to this runs out and does it. They don't do it the right way. And all of a sudden, we're both getting sued.
Yeah, don't sue us, you guys. This is just for informational and educational purposes only. Yeah, and that's, I think, important, too, is I think because, and sorry I interrupted, but, people want, a straight answer, and, we can only do so much in contexts like this, but that's why it's so important to talk to a lawyer who's authorized to practice law, in your jurisdiction or has the background in that topic area that you have a question about, because we need to get more information to give you an answer, and just we don't have all the facts.
So I do a weekly thing on Reddit where I give out legal guidance to people's questions. But the number one rule of that, both legally I'm not allowed to and morally it would just be silly, is we can only give general answers. You can't give specific answers because your specific facts will always change the generic legal answer. So you should always pick up the phone and just call a lawyer. They're free to talk to almost always for the initial consultation, and then you can see if it's worth getting help.
Yeah, I remember my first year in law school, my contracts lawyer said, you're going to get used to every time you ask a lawyer a question, the answer is, it depends. It always depends. And it's just the way the law is, unfortunately. So cool. So this has been really good stuff. So is there any other kind of tips and tricks that you could share with our listeners about what they should be thinking about when it comes to the law and their business and growing and things that you're seeing kind of on the, you're kind of there on the horizon that people need to be considering?
Yeah, I would say the first thing that is free, doesn't involve a lawyer and all that other stuff, is Google around and see if your name's taken. Because so many times we have people coming in saying, hey, I want to start a shirt company. It's called Shirts. Okay, but that's used. You can't just do that. Just do some basic homework before you fall in love with a name, before you spend money on marketing, brand, or whatever it might be. just do a basic Google search and you'll type in your name and then what industry you're in and see if other people are already using it or doing it. Because even if they have, one shirt for sale from 3 years ago and they haven't done anything with it and they're a small company, there's still very much the real possibility that they have rights to it and you don't. And that's when you want to be careful.
And so in that situation, is it just best to pick another name? Or let's say you're really attached to a name. Do you reach out to them, or what do you recommend?
There's a couple options. So the first is you reach out to them personally. The downside with that is if they say no, now you're on their radar and now you're more likely to get sued than you were before. But a lot of times they'll say yes. The second option is you offer them money to buy the rights to the name. And the third is you kind of just pretend they don't exist and you do the cost benefit analysis of, are they going to sue me? You try to work that out. Again, just disclaimer. I think that's always better to work out with a lawyer, but that's something to definitely think about.
Yeah. And I get a lot of questions like, well, I've been using this domain like .com and now somebody's using .net or .co. So what's your answer there in terms of... Yeah.
Yes, so good you brought that up because I almost forgot to say that and I would have kicked myself. So marketing material does not matter. I don't care if you've been promoting the name of your soon-to-be company for 3 years and someone comes out with a name tomorrow that actually uses it, quote unquote, in commerce. The second you sell an actual product or offer an actual service, even if it's free, that's when you're now protectable. That's when your trademark becomes protectable. You're having a URL, having a domain name, or having a Twitter handle, having a Facebook group, none of that matters at all. And you want to make sure that you have something real and viable to offer the public. Otherwise, you have no rights to that name.
But if you're using that name in order to sell things, so let's say you have t-shirt company X, right? .com. And that's the name of your company. Well, we're being really generic. It's not a good example, but you know what I mean? If you have like brandname.com and you're selling things, then you have then rights to that domain name because you have been putting your goods and services out in the public under a brand name. Right?
Exactly. And it's so the nice thing with trademarks is they're a sword and a shield, to get old law professor cliche on you. The shield is nice because if someone tries to sue you for infringement, you hold up your trademark and say, nah, I own this. And the sword's nice because just like I can't open McDonald's Burger Company, someone else can't steal your name and just change the .com to a .net or change one of the letters. The test is still confusingly similar. So if your name is, when the law says confusingly, it means confusing to an idiot. So if the dumbest person in the world would be confused by those two sources, you have an argument to shut down that other guy. And it's super easy to do usually. And I recommend it because you got to protect your brand. That's important.
And so how soon in the process do you recommend that people consider trademarking their name? I always recommend definitely, do the search before you start using a name because you don't want to be infringing on somebody else's. But at what point do you recommend that they actually register or file a registration with the trademark office?
The method that almost every major company does, which means it's probably one of the better methods, and it's the one we agree with entirely, is 6 months to a year before you're going to release your product, you put in your trademark. So there's two ways to file a trademark. It's when you're already in commerce, or it's when you have an intent to use. And the intent to use is good because it will make sure that you're registered the second you're ready to launch, as opposed to having to wait 6 months to a year after you launch when you file it.
Okay, cool. That's actually a really good point. And so, if you're going into market, you're going to be investing a lot of money and time into a name and building that, then, it's nice to know that you have this option of kind of reserving the name. You still have to register it once you start using it, but you can kind of hold the name and make sure that it's available by filing an intent to use application. And then one last question. So with office action, so sometimes for folks who don't know, sometimes you'll file something with a trademark and then the trademark examining attorney will come back and say, yeah, we're probably not going to grant you this because of XYZ. And so not really the procedural issues, but more of like the substantive legal issues. What's been your experience in terms of responding to those office actions, and like how likely is it at that point to get something registered as a trademark?
So what an office action is exactly what you said. It's not a no, it's a no unless, and then something, something, something. But the problem is it's written in 15 pages of legalese. They cite a bunch of case law. It's a very intimidating document. So when the average non-attorney gets that and looks at it on LegalZoom, they say, that stinks, I got a no. They didn't get a no, because sometimes you can fix that stuff in a quick phone call. But what it says on the bottom there, on almost every one of them is, it literally says, like, we know this is complicated. Please call an attorney. We can't give you advice, but it's not dead. Please talk to someone. Like, the government's almost begging you to not give up. And when you use an attorney, that 5% success rate around with LegalZoom shoots up to almost 80%, even with not a very good trademark attorney. With attorneys who specialize in it and really focus on it, I think we've lost. So we've done over 350 trademarks last year, and I think we lost maybe 2 of them. Prior results don't guarantee future outcomes and all that. But, we're a trademark law firm, so we know trademarks really well. And so do other trademark lawyers. If you know the argument and you did proper clearance before you put in the application, you can almost always get through and you're ready for those arguments and you handle them the right way.
Mm-hmm. So if you do get an office action, it's always good to talk to a lawyer, a trademark lawyer who has experience practicing or responding to those, because you do need to present some legal arguments sometimes. It's kind of like writing a brief, right?
Well, but just to be honest with everybody, because I'm big on the transparency side, that the law doesn't have to be so scary. The best thing you can do also is take a breath, realize that this is going to stink for an hour, but just read it. Sometimes it'll literally be 7 pages and all it says is, we want you to say that your logo is dark blue instead of blue. And for some reason, there's 7 pages to get to that. But that's all they want. They want you to call up and say, I agree with you saying dark blue instead of blue. And if you just read that, you don't even need to pay one of us.
Yeah. Yeah, because it's more of like a little procedural thing or like an easy thing. But if it's a substantive thing, like, well, we found this other trademark and it's confusingly similar.
That's when you'll need a lawyer.
And those tend to be a little bit more difficult to get approved, right?
Yeah, that's exactly what you said. It's like a brief if you're going into a courtroom. And it basically is litigation, but through their website instead of in a courtroom. So that makes it way cheaper, and it makes it, you'll know your chances of victory before you spend $1. But a lot of those, even if they say this trademark's too close to this other one, you can still win that if you cite the right case law. Okay.
Good to know. Good to know. Ryan, I love your enthusiasm and your energy about this stuff. It's intoxicating. No, I'm just kidding.
Well, I appreciate it.
Hopefully our listeners, I'm sure they'll feel the same way. Any last minute things you want to add before we sign off?
No, it's been a pleasure. Thanks for having me. And, always happy to answer any questions anyone has later on.
Awesome. We will link up to all of your website and all of your resources in the show notes so they can find you. So thank you so much for being here.
My pleasure. Thanks again.
So that's what happens when you get 2 lawyers together talking about the law. #nerdalert, right? If you want to learn more about Ryan as well as his practice, you can find all the details over in the show notes at AnnetteStepanian.com/podcast/30. And if you're thinking, oh my goodness, I don't have a privacy policy, I don't have a terms of service, oh my God, what do I do? Well, fortunately, I offer those as contract templates over on the site as well. So you can get those, you download them, you customize them, and there you go. You're all good to go there. And if you're interested in working together on trademarks, we have questions about those. That's a service I provide as well. And you can learn all about that over on the website at AnnetteStepanian.com. So with that said, my friend, I hope you have a fantastic day, and I can't wait to talk to you later.